EU laws are a popular subject of discussion in pubs and cafes all over Europe. But how do we get these laws and who makes them? For a new EU law to come into existence, someone must first have an idea for a law, make a draft for it, officially propose it, and then have it accepted. The right to propose a new law, called the right of initiative, officially lies solely with the Commission. This means only the Commission may propose new laws. The EU wouldn't be itself, however, if there weren't some exceptions to this rule. So while the Commission has the only official right of initiative, others also have ways of putting their ideas on the table. For example, when the majority of the European Parliament feel that common law is required to reach certain goals, it may ask the Commission to draft a proposal for new legislation. The Commission does not have to honour such a request, but it has to give an explanation if it chooses to refuse it. The Council can also try to initiate new laws by asking the Commission to explore whether common legislation on a subject would be useful. If the Commission finds good reason for common laws, it would be very strange for them not to draft a proposal. So, although with a bit of a detour, both Parliament and the Council can cause new common legislation to be created. However, it is always the Commission that drafts and proposes laws, and in both cases the Commission can choose not to do so, as long as it explains why. We won't go into too much detail, but it is worth mentioning that of course the EU is not as simple as this. These ways of initiating new laws are not the only ones. The regular legislative procedure can be launched in some way or another by a quarter of the EU member states, the Court of Justice of the EU, the European Investment Bank, or the European Central Bank. These institutions, however, can only do this in certain subjects. Last but not least, you may take it into your own hands to create new EU law. You can do so directly by gathering signatures of at least 1 million EU citizens from at least 7 member states. Or, when you're on your own, you can submit a petition to the European Parliament, as is every EU citizen's right. Or of course, in a more indirect way, you can bring it to the attention of the Parliament simply by lobbying with its members. Once the initiative for a proposal has been taken, the Commission starts the consultation process, meaning the Commission gathers information in all kinds of ways, for example by asking experts, international organizations and NGOs. In this process, the terms green or white paper are often mentioned. These documents are used to invite or inform other parties of the proposed legislation. Once the consultation process is ended, the College of Commissioners adopts the proposal. After the Commission have drafted a proposal of the new legislation, they send it to Parliament, to the Council and to all national parliaments. If both the Council and the Parliament simply accept the proposal, it is passed. If Parliament does not fully agree, it may amend. The Council then considers the amended version of the proposal and can either accept it, passing the proposal, or amend it itself, sending it back to the Parliament for a second look. Parliament may then accept or again amend it and send it back to the Council. If these two have not worked it out by then, a commission consisting of members of Parliament and the Council tries to agree on a new version. If they can't come together, the process ends here. If, however, they make a new version, yes, you guessed it, both Parliament and the Council have a third look. Here they may only accept or reject. They can no longer make any changes. This is to make sure that the process does not go on forever. But what about the third group that got sent the draft? If Council and Parliament can pass the proposal on their own, why did the Commission even send it to the national parliaments? While national parliaments do not have to do anything for the process to continue, they can do something to stop it. If they think the proposed legislation goes against the principle of subsidiarity, they can object with the 2 votes each member state has. The principle of subsidiarity prevents the EU from unnecessarily infringing the national government's legislative power. If 1/3 of national parliaments object, the proposal received a yellow card and it must be reviewed. Based on this review, the Commission may choose to maintain, amend or withdraw the proposal. If maintained or amended, the process continues. If it chooses to withdraw, the process ends. If more than half of the national parliaments object, an orange card is drawn, and a similar process of review is started. However, in case of an orange card, the Commission must explain its position if it decides to keep the proposal without change. Both Parliament and the Council must then decide whether they agree with the national parliaments or with the Commission. If more than half of either Parliament or the Council agrees with the objecting national parliament, the proposal is dropped. Now, this entire process is not the most straightforward, even in the simplified form, so let's go over it once more. A proposal of new legislation is made by the Commission itself, the European Parliament, the Council, any EU citizen, or depending on the subject, a quarter of the EU member states, the Court of Justice of the EU, the European Investment Bank, or the European Central Bank. Then the Commission, with the help of all kinds of experts, drafts a proposal. After that, the proposal is reviewed by the Council and Parliament and is open for objection from national parliaments. If the proposal manages to get through this process, it is passed and comes into force immediately. If that's not complicated enough, there are 3 forms a new EU law can come in: a decision, a regulation, or a directive.
To find out more about the other institutions, the history of the EU and other subjects, please check out our playlists and subscribe to our channel.